Hello everyone, and thank you for joining me for December 2018, my PIP Monthly. My name is Javon David, and I'm a partner at Secrest Wardle's Troy location. I'll be going over some case law here today, and we'll also talk to you about some recent updates in the law. We've got 3 cases to discuss. Actually, technically 4. 2 of them are published decisions, but I saved one of the cases for the trending topics and PIP litigation portion, just to give you guys an idea of what's gone on with the Bazzi case that we've been following as our firm has handled it from start to finish all the way to the Court of Appeals and back down to the trial court level. And, it's obviously a very important case in fraud cases. So going through the initial Court of Appeals update, the first case on our agenda is the Melek versus State Farm case. And it's Melek Hamedian versus State Farm Mutual Insurance Company. This again was a Secrest Wardle case handled by Paul McDonald and Olga Casina from our firm. So in that case, which is a published decision, the Court of Appeals held that to determine whether an insurer is the motor vehicle insurer for purposes of MCL 500.3114, which is the priority statute, the analysis hinges on whether there are any motor vehicle policies that are required to provide personal protection insurance coverage that would cover a motorcycle rider. So in this case, just by way of background, the plaintiff was injured in a motor vehicle accident while he was operating a motorcycle owned by Progressive insured Guillermo Flores. There were other issues in the case that did not make it to appeal, but the primary issue was whether or not the plaintiff would be entitled to PIP benefits from Progressive or if he would be entitled to PIP benefits from State Farm. So the case encompassed an operator of a motorcycle involved in an accident that showed some evidence of the involvement of a motor vehicle. That triggers 500.3114 subsection 5 of the No Fault Act, which provides that personal protection insurance benefits shall be claimed from insurers in the following order of priority. First, the insurer of the owner or registrant of the motor vehicle involved in the accident is primary. If there is none, the insurer of the operator of the motor vehicle involved in the accident is primary. If none, then the motor vehicle insurer of the operator of the motorcycle involved in the accident is primary. And again, if there's none, then the motorcycle insurer of the owner or registrant of the motorcycle involved in the accident is primary. So plaintiff initially filed their lawsuit against State Farm, arguing that he was a resident relative of State Farm insured his mother, Ada Hamedian. Therefore, he argued he qualified for PIP benefits under the State Farm policy. What's significant here is that State Farm had a broad definition of insured, which included resident relatives, and that was contained specifically in the policy. So the parties went through extensive litigation in the case, all agreeing that the determinative issue of priority would be where plaintiff was domiciled and where he lived at the time the accident occurred, and whether or not he would be entitled to benefits from State Farm. The parties filed competing motions for summary disposition after the close of discovery, and the trial court found that State Farm could not be plaintiff's motor vehicle insurer because plaintiff did not own a motor vehicle. The trial court reasoned that plaintiff's domicile was irrelevant and held that Progressive was the insurer highest in the order of priority. Ultimately, Progressive, represented by Olga Casina of our firm and Paul McDonald, went to the Court of Appeals and argued that the term motor vehicle insurer was incorporated by the legislature to ensure priority returns to a motor vehicle versus a motorcycle insurance policy, and that one needs to look at the applicable policy language, which in this case would be the State Farm policy, to determine whether a particular auto policy would provide for personal protection insurance benefits to an injured person. On appeal, State Farm argued that the plain meaning of the statute requires that an injured motorcyclist own a motor vehicle for there to be a motor vehicle insurer. Ultimately, Progressive prevailed in the Court of Appeals, and the Court of Appeals agreed with Progressive's position, noting that courts should not abandon common sense when construing a statute. And here, the legislature used the phrase motor vehicle insurer to delineate between the injured party's motorcycle policy and any applicable motor vehicle policies. So ultimately, State Farm was found to be primary because the plaintiff was a relative of his mother. And the court ultimately sent it back to the trial court to make that determination. So what is the takeaway from this particular case? It gets a little tricky when you're handling a claim involving a motorcycle and it's a first party action. So you're always going to want to look to the language of the statute, but you're not going to completely abandon looking at the policy language itself, and whether that be your own policy language or the policy language of any other motor vehicle involved in the collision, to see if the policy itself extends coverage to individuals such as the plaintiff in this case, pertaining to resident relatives. So the rule to take away here is that in determining whether an auto insurer is the quote-unquote motor vehicle insurer for purposes of the statute, it's important and imperative, quite frankly, to analyze the applicable policy language of the vehicles involved in the collision. The reason Progressive contended and the Court of Appeals agreed that State Farm was in the order of priority was particularly because State Farm's policy language expanded the definition of an insured to a resident relative. So just something to keep in mind when you're handling those kinds of cases. So you're going to want to get the policies for all the vehicles involved, review them, and determine if there's coverage available through some other insurance that may or may not be your own. Now, the next case we've got today is the ZIF Q versus James case, which is an unpublished decision. This is actually a bodily injury claim, but I'm talking about it in the PIP podcast because it does shed some light on evidentiary issues that can come up in bodily injury cases and PIP cases. Now, this case is truly a cautionary tale as to the importance of properly filing witness lists and properly disclosing to plaintiff who will provide expert testimony at the time of trial. So I won't spend too much time on the facts of this one because it's a BI case and this is my PIP Monthly. But essentially, this involved a motor vehicle accident involving the two parties. The plaintiff filed a lawsuit alleging negligence against the two defendants and additionally alleged owner's liability, vicarious liability, the whole works, negligent hiring, retention, all of that. So what's key here is that at trial, the plaintiff elicited testimony from the investigating police officer who was a state police sergeant. The sergeant investigated the scene of the accident and further collected additional data from both of the vehicles. The sergeant offered testimony as to his training and experience as a quote-unquote crash reconstructionist and his whole calculation as to who was at fault for this accident. So ultimately, the sergeant found that defendant was at fault for the accident as they failed to stop at a clear distance before striking the plaintiff's vehicle. At the close of proofs at trial, the trial court granted defendant's motion or plaintiff's motion for directed verdict regarding whether defendant was negligent and whether plaintiff sustained a threshold injury. In its ruling on directed verdict, the court noted that Sergeant Stone's testimony was very persuasive in regard to defendant's negligence. So essentially, the trial court relied quite heavily on this officer's testimony in ruling in favor of the plaintiff regarding a directed verdict. On appeal, the defendants argued that the trial court erred by allowing Sergeant Stone to testify regarding whether defendant violated the state statute regarding whether or not someone stops at an assured clear distance. And defendants maintained that Sergeant Stone's testimony was presented in the form of expert testimony, which was improper. In fact, they argued that he was never disclosed as an expert on any witness list that was filed. And more importantly, he was never qualified as an expert by the trial court. Now, the Court of Appeals looked at all of the training, they looked at the testimony, and they ultimately held that the trial court did err, meaning they made a mistake when they admitted Sergeant Stone's expert testimony at trial. Specifically, the trial court never made any findings as to whether Sergeant Stone was qualified to testify as an expert. And in addition, the plaintiff never disclosed this individual as an expert regarding fault. They just listed him on the witness list as the investigative officer, but did not state that he would be called to testify regarding fault, that he did all these calculations, and that he had a whole analysis to present to the trial court regarding liability in this case. Now, this is an important lesson on your cases, and when you're thinking about how to work with your counsel on cases that go to trial, You're going to want to make sure that your counsel identifies experts properly in the witness list and that you're all in agreement as to who will be serving as the experts at trial. And you're going to want to disclose what expert testimony will be expected to be presented at trial. Otherwise, you'll face these kinds of issues where the expert will be stricken. So that's the key takeaway here is you want to avoid having your experts stricken at trial. You want to avoid having them stricken in the whole discovery and in the case itself. So just work with your counsel to make sure you're all on the same page and to how to avoid doing that. In Holman versus Mosa Basha, the Michigan Court of Appeals looked at the statutory notice of expiration of coverage under MCL 500.3020. And note this is an unpublished opinion and is not binding authority. However, the decision confirms that notice under the statute is only required when a policy will be canceled within the policy period. Based on this ruling, it appears this could also apply to binders or certificates of insurance as well. Nevertheless, once coverage expires, any notice of non-renewal is not necessary. So, in June 2013, the plaintiff purchased a used Chevy Malibu and insured it with AAA. The policy was effective June 12, 2013 and expired December 12, 2013. The Malibu was in possession of plaintiff's ex-girlfriend, a woman named Jamie Williams. The plaintiff eventually took back possession of the vehicle after finding out that Williams was not paying the insurance premiums. Plaintiff looked into obtaining insurance, but he ultimately didn't. He admitted to driving the Malibu a few times while it was uninsured. The vehicle was eventually repossessed in October or November of 2014, which is almost a year after the insurance had expired. On December 30th, 2014, plaintiff purchased a 2007 Mercury Mountaineer. He spoke with a Farm Bureau sales agent in an attempt to secure insurance coverage. Plaintiff provided the requested information and was ultimately presented with an application for a 6-month insurance policy. Plaintiff signed the application on December 31, 2014. The application specifically asked, has the applicant or a member of the applicant's household driven or moved any vehicle owned by the applicant which has not had the required insurance in force for the preceding 6 months? Plaintiff answered no because he thought that his prior insurance was in place. Plaintiff did receive a certificate of no-fault insurance from Farm Bureau with an effective date of December 30, 2014. On January 30th, 2015, Farm Bureau sent plaintiff a letter explaining that his application was not accepted because it was incomplete. He was refunded his initial payment. According to Farm Bureau's underwriting representative, the reason the application was considered incomplete was because it was missing plaintiff's proof of prior insurance. Plaintiff claimed he did not receive the letter before the February 5th, 2015 accident. Plaintiff sustained serious injuries in the accident and was in a medically induced coma for several weeks after the accident. He learned of the letter after regaining consciousness. Plaintiff's claims against Farm Bureau were dismissed by the Circuit Court, which concluded that Farm Bureau never issued an insurance policy to plaintiff and their certificate of insurance was only a binder meant to enable plaintiff to register his newly purchased Mountaineer. The lower court also reasoned that even if the certificate was a short-term policy, it had expired on its own terms. So there is no notice required under 3020 of the No-Fault Act. The parties then appealed this decision, and the Michigan Court of Appeals disagreed with plaintiff's categorization of the certificate of insurance as a temporary policy. The court noted that binders are issued in automobile insurance situations to allow the applicant to use the car while waiting for a decision from the insurance company as to whether or not it will insure a driver. It's not in and of itself an applicable policy of insurance. In this case, plaintiff's certificate of insurance expired 2 weeks before the accident. Plaintiff argued that because he did not have notice of the expiration, that he was still entitled to coverage. However, the court correctly found that notice was not required because the binder expired on its own terms. In fact, the certificate of insurance only provided coverage until the expiration date shown on the certificate, which again was before the accident. The Court of Appeals also agreed that even if a policy existed, Farm Bureau would have been entitled to rescind the policy ab initio because of plaintiff's misrepresentations in the application process. The court went through the whole assessment of rescission obviously determining that it is well settled that a material misrepresentation made in an application for no-fault insurance entitles the insurance company to rescind the policy. A fact or representation in an application is considered material when communication of it would have the effect of substantially increasing the chance of loss insured against the individual or the carrier in charging an increased premium. So ultimately, the Court of Appeals agreed that the notice provision of 3020 of the No-Fault Act is only required when a policy will be canceled within the policy period. And additionally, the court affirmed that an insurer has a right to rescind an insurance policy when there are material misrepresentations in the application process, especially when the misrepresentations relate to coverage guidelines. So those are the main cases that come down from the Court of Appeals this month that kind of shed some insight into important avenues or important issues to consider in claim handling and in litigation when you're working with defense counsel on your cases. Now, for the trending topics in PIP litigation, we've all been following Bazzi decision and all the case law that has been coming down from Bazzi. And the Michigan Supreme Court issued an order that does shed some light as to how cases should be handled in a post-Bazzi area. And this case is Farm Bureau versus Ace American Insurance Company, which was released this month. In that case, the Michigan Court of Appeals remanded this particular action to the circuit court to determine whether rescission is available as an equitable remedy between the claimant and Farm Bureau. As a brief refresher, and you can check out the multiple podcasts and webinars that our firm has done regarding Bazzi for a more in-depth discussion as to what exactly it held and how it affects your claims. But in Bazzi, the Michigan Supreme Court explained that when a plaintiff is seeking rescission, the trial court must balance the equities to determine whether the plaintiff is entitled to relief that he or she seeks. Further, just as the intervening interest of an innocent third party does not altogether bar rescission as an equitable remedy, neither does fraud in the application for insurance allow an insurer to have an absolute right to rescission with respect to third parties. Now, in this particular order, the order itself just simply sends the case back to the circuit court. But Justice Markman wrote separately in the order to discuss the need to establish a coherent and workable standard by which trial courts are to exercise their discretion in innocent third-party cases. He spends most of the opinion, quite frankly, talking about the dangers of not having these standards in place. He goes into particular depth about how if we don't have a legal standard, then every trial court judge is essentially going to be able to make these determinations on their own and to set their own standards. So one judge might have a very stringent standard as to how to balance the equities and determine if a rescission was proper, whereas another one might have a completely different standard. So he's trying to provide some guidance to the trial courts and say, when you have a Bazzi case or in front of you or a case that has a rescission issue in a post-Bazzi world, what are you supposed to look at as the trial court judge? And while it's important from the judge's perspective, it's even more important from the defense perspective and the plaintiff's perspective as to how you're going to make the arguments that the third party was not innocent, or alternatively, that the insurance company was innocent in this process and should not be stuck with someone's bill for first-party benefits. So the cases go, or the judge, Justice Markman, goes through a list of 5 factors, and I'll go through them here for you. He says, first, when you're looking at balancing the equities, you want to look at the extent to which the insurer investigated or could have investigated the subject matter of the fraud before the innocent party was injured, which may have led to a determination by the insurer that the insurance policy had been procured on a fraudulent basis. If the insurance company could have, with reasonable effort, obtained information indicating that the insured had committed fraud in procuring the policy, then equity might weigh against rescission in that case because the insurer could have acted without adequate professional diligence in issuing and maintaining the policy. So what does all that mean? That is essentially saying that if you have a situation where the insurance company issued this policy without actually checking on the information that was submitted to them to see if it was accurate, then they may not necessarily be entitled to rescission. It just kind of goes to show that you can't just, like rubber stamp these policies and just argue after someone was injured that they're not entitled to benefits. Second, Justice Markman states that we must look at the specific relationship between the innocent third party and the fraudulent insured. If the innocent third party possessed some knowledge of the fraud, perhaps because of a family or other relationship, then equity might weigh in favor of rescission because that individual is seeking to recover from the insurer despite knowledge of the fraud. Third, the precise nature of the innocent third party's conduct in the injury causing the event. Where the innocent third party acted recklessly or even negligently in the course of the injury causing event, equity might weigh in favor of rescission because the innocent third party could have avoided the injury by acting more prudently. And in particular, in the Bazzi case, the plaintiff was driving double the speed limit when he was involved in the accident. So, for example, that particular fact would be analyzed under this proposed third prong or standard of Justice Markman. The fourth prong is whether the innocent third party possesses an alternative avenue for recovery absent enforcement of the insurance policy. For example, and as is argued in the Bazzi case itself, the assigned claims plan is one avenue for recovery that is not the particular policy that's at issue. In addition, you want to look at whether or not the claimant has health insurance. If so, then you would argue and you would contend that they are not left without remedy in the particular claim. If their claim is rescinded or the policy is rescinded, they can go to the MACP or they can go to their own health insurance carrier. So where the innocent third party possesses an alternative means of recovery, equity may weigh in favor of rescission because the insurer need not suffer loss due to the fraud. And finally, the final factor that he provides is whether enforcement of the insurance policy would merely relieve the fraudulent insured of what would otherwise be the insured's personal liability to the innocent third party. What that means is whether enforcement of the insurance policy would subject the insured to coverage for tort liability for an at-fault insured. In such a case, equity may weigh in favor of rescission because enforcement of the policy would transfer liability to the innocent third party from the insured who committed the fraud to the insurer that did not commit any wrongdoing. So those are the 5 factors that he points to in this particular order, but he specifically states, again in a lengthy extended opinion, that these factors are not exhaustive. These shouldn't be the only factors that are considered. And while certainly trial court judges use their own discretion and it's all looked at on a case-by-case basis, these are the kinds of things that we need to have in place in order to have a sufficient legal standard. He offers these as some guidance to both the judges as well as the attorneys that are litigating these cases in a post-Bazzi era. So hopefully this overview will be helpful to you in your claim handling in Bazzi cases, or if you're a litigation specialist tuning in, you can point to this particular opinion in any subsequent motion that you're required to file after Bazzi came down from the Supreme Court. If you have any questions, please contact me. My contact information is located on the last slide here. But again, this is Javon David from Secrest Wardle's Troy location. Thank you for listening, and I look forward to speaking with you next month.